This is The Right Slant, and today we are going to break down, step by step, a Supreme Court ruling that many Americans are just now learning about, a ruling that did not repeal the Fourth Amendment, did not amend it, did not strike it from the Constitution, but in practice stripped away one of its strongest protections, the right to be secure in your own home. The case is Case versus Montana, decided earlier this year. And to understand why this decision matters so much, you have to look not just at the legal language, but at the actual facts on the ground. Because the facts tell a story the court chose to ignore. The Fourth Amendment is very clear. It says the people shall be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The home is not just another place under the Fourth Amendment. It has always been treated as sacred. Historically, if the government wanted to cross that threshold, it needed a warrant signed by a judge based on probable cause. That was the deal. That was the line. There have always been narrow exceptions. One of those is exigent circumstances, sometimes called the emergency aid exception. The idea is simple. If someone is about to die, if someone is screaming for help, if there is an immediate and ongoing emergency, police do not have to stand outside while a person bleeds out just to get paperwork signed. That exception exists to save lives, not to bypass the Constitution. Now let's talk about what actually happened in this case. Police received a call that raised concerns about a possible mental health or safety issue inside a private home. What they did not have was clear evidence of an immediate emergency. No screams, no sounds of violence, no gunshots, no fire, no visible injuries, no one actively calling for help from inside the home. And here is the most important part, the part that cannot be argued away. The police did not rush in. They waited. They waited approximately 45 minutes. During that 45 minutes, officers did not attempt emergency medical intervention. They did not call for paramedics to stage nearby. They did not treat the situation as someone who might be moments from death. Instead, they geared up. They put on body armor. They changed into tactical equipment. They prepared for a law enforcement operation, not an emergency rescue. That matters. It matters a lot, because exigent circumstances are defined by urgency. If you genuinely believe someone inside is in immediate danger, you do not wait nearly an hour while you prepare for a tactical entry. You act. The officer's own behavior demonstrates what they actually believed at the time, that this was not an immediate life or death emergency. Under decades of Fourth Amendment law, that kind of delay would normally kill any claim of exigency. Courts have repeatedly held that if officers have time to plan, to coordinate, to gear up, or to secure the scene, they usually have time to seek a warrant. And seeking a warrant is not optional under the Constitution. It is the rule. Yet in this case, the Supreme Court ruled that the warrantless entry was constitutional anyway. The court said that officers only needed an objectively reasonable belief that someone inside might need aid, not proof, not immediacy, not conduct that matched the claim, just a belief. That is a massive shift. Before this ruling, courts looked at what officers did. Did they rush? Did they hesitate? Did they treat the situation as urgent? Actions mattered. Reality mattered. Time mattered. Now, after this ruling, what matters most is what officers say they believed, even if their actions tell a completely different story. This is where the Fourth Amendment starts to collapse in practice. Think about what this means going forward. Police can receive a vague report. They can secure a scene. They can wait. They can plan. They can gear up. And then, after all of that, they can still claim an emergency to justify entering your home without a warrant. The constitutional check is gone at the moment it matters most. The judge never sees it beforehand. The warrant never gets reviewed. The decision is made entirely by the officers on scene, and the courts are instructed to defer to their claimed belief afterward. That is not how the Fourth Amendment was designed to work. And this is where we need to pause for a moment. If this breakdown is helping you understand what just happened to one of your core constitutional rights, take a second right now to like this video, subscribe to The Right Slant, and hit the notification bell so you don't miss future deep dives like this. These cases don't get explained clearly anywhere else, and YouTube is not going to push this kind of content unless you help it along. Back to the ruling. Supporters of this decision argue that it helps police act quickly to save lives. But that argument falls apart when you apply it to the actual facts of this case. You cannot claim urgency while waiting 45 minutes. You cannot claim emergency aid while suiting up for a tactical encounter. Those two things are legally and logically inconsistent. This decision effectively redefines exigent circumstances so loosely that almost any situation can be framed as an emergency after the fact. That destroys the narrowness of the exception and turns it into a shortcut. And once shortcuts exist, they get used. From a conservative constitutional perspective, this is deeply troubling. The Fourth Amendment is not about trusting government actors to do the right thing. It is about limiting government power precisely because even well-intentioned power can be abused. The founders did not write the Fourth Amendment to be flexible. They wrote it to be firm. Warrants were supposed to be the default, not an inconvenience that officers can bypass with vague claims. This ruling shifts power away from neutral judges and concentrates it in the hands of the state. That is the opposite of limited government. And let's be very clear about something else. This does not just affect criminals. This affects ordinary people. It affects gun owners. It affects people with mental health struggles. It affects anyone who lives alone. It affects anyone who has ever had a neighbor call the police just to be safe. Under this ruling, your front door is no longer the hard constitutional boundary it once was. The most dangerous part of this decision is not what it says outright. It is what it signals to lower courts and law enforcement agencies. It tells them that timing does not matter. Preparation does not matter. Tactical posture does not matter. As long as an officer can articulate a belief, the warrant requirement can be sidestepped. That is not how rights disappear. They don't vanish overnight. They erode case by case, exception by exception, until they exist only on paper. And that is exactly what happened here. The Fourth Amendment still exists. The words are still there. But the protection it was meant to provide inside your home has been significantly weakened. This case will be cited for years. It will be taught in police academies. It will be used in courtrooms to justify entries that would have been unconstitutional just a few years ago. And once that precedent is set, it is almost never rolled back. That is why this case matters. Not because of headlines, not because of political talking points, but because it changes the balance between the citizen and the state at the most personal level possible, your home. If you value limited government, individual liberty, and constitutional boundaries that actually mean something, this ruling should concern you. As always, this is the right slant. If you want to keep understanding how these decisions really affect your rights, stay tuned. YouTube thinks you'll like the video on screen right now, and thanks for watching.